you do not have a Fifth Amendment right. We don't have rights anyway, okay, guys? It's all illusory. You can, at 2:30 this morning, while you're fast asleep, trying to get rest for your next day at work so that you can, try to put food on your family's table and a roof over the head and clothes on your back. At 2:30 this morning, the feds could break down your door. Whether it's the right door or not, they don't care about the address. They don't care about the ramifications. They don't care about the consequences. They don't care about the loss of life. Pizza delivery drivers are more accurate in getting the right address than a SWAT team who's coming to do somebody harm. They don't care if it's the wrong address. But at 2:30 this morning, you could have your door broken down, your windows shattered, flashbangs going off, your life in jeopardy, your dog killed, all because they got the wrong house. Because we don't have freedom in America. There's nothing to stop them from doing that. Helicopters in the sky, dogs on the ground, cruisers at full speed, putting people in danger. They have qualified immunity. Badges and uniforms in their minds grant special rights. So if you think we have rights, you got to wake up and smell the coffee and figure out what's really going on. And in regard to the Fifth Amendment, even according to the black-robed tyrants of the Supreme Court in Salinas versus Texas, you don't even have a Fifth Amendment right to be silent or have that silence work for you unless you specifically, unequivocally invoke that right. Let me go over this real quick. I'm just going to read it word for word because it's a pretty interesting case. And it's also interesting how the black-robed tyrants take full advantage of what they've given themselves back in 1803 with Marbury versus Madison, and they've given themselves the power of judicial review. In other words, they can look at the Constitution and they will determine what it means, and they will determine how it's applied, and they will determine if you've lived according to the standard of the Constitution. So that makes the Constitution not the supreme law of the land, but the interpretation of the Constitution by the black-robed tyrants of the Supreme Court. And so here are the facts of the case. In 1992, Houston police officers found 2 homicide victims. The investigation led officers to Mr. Salinas. Salinas agreed to accompany the officers to the police station where he was questioned for about an hour. Salinas was not under arrest at this time and had not been read his Miranda rights. Now, this is in 1993. Miranda came around back in 1966. That was Ernesto Miranda. That was that case there. Salinas answered every question until an officer asked whether the shotgun shells found at the scene of the crime would match the gun found in Salinas' home. According to the officer, Salinas remained silent. We're going to find out why that's a problem here in a second. And demonstrated signs of deception. Oh, he was squirming in his seat. He was blinking his eyes. He was shifting his weight. He was crossing his arms. He was exhibiting signs of deception, according to the police officer. The ballistics and analysis later matched Salinas' gun with the casings at the scene. Police also found a witness who said Salinas admitted to killing the victims. In 1993, Salinas was charged with the murders, but he got the heck out of Dodge and he could not be located. 15 years later, check this out. Salinas was finally captured. The first trial ended in a mistrial. At the second trial, the prosecution attempted to introduce evidence of the Salinas' silence about the gun casings. Salinas objected, arguing that he could invoke his Fifth Amendment protection against self-incrimination whether he was in custody or not. We're going to find out in a second that the black-robed tyrants of the Supreme Court said, no, that's not the way it works. Because we say it's not the way it works. We're just going to make a carte blanche arbitrary edict here. The trial court admitted the evidence and Salinas was found guilty and sentenced to 20 years in prison and a $5,000 fine. The 14th Court of Appeals, Harris County, Texas, affirmed, noting that the courts that have addressed this issue are divided. The Court of Criminal Appeals of Texas affirmed. So the question is, does the Fifth Amendment self-incrimination clause protect a defendant's refusal to answer questions asked by law enforcement before he has been arrested or read his Miranda rights? In other words, do you have Fifth Amendment protection just by remaining silent? Here's another question. Do you have Fifth Amendment protection against self-incrimination by saying, I don't answer questions? You know what the Supreme Court says? Nope, you don't. You don't have Fifth Amendment protections unless you specifically and unambiguously say, I invoke my right to remain silent. That's what the Supreme Court's saying in Salinas versus Texas. And basically, whether we like it or not, yeah, it's not a real law like the law of gravity or the law of, entropy. It's not a real law. All laws are backed by the threat of force. It's the opinions of political parasites backed by the threat of force. And who initiates that force? The law enforcement class. So the political class makes the rules, and the law enforcement class enforces those rules. If you step out of line, whammo. But even within their own rules, there are these certain magic words that you got to say or you don't have the rights. How many Americans do you think know that they don't have the right to remain silent unless they specifically invoke the right to remain silent? I bet very, very few. I bet there's a lot of people out there who think that it's okay just to say, I don't answer questions and then to remain silent. You haven't invoked your Fifth Amendment right according to Salinas versus Texas. And let's read this. So the question is, does the Fifth Amendment self-incrimination clause protect, let's just boil it down, protect you just by remaining silent? The answer by the Supreme Court is no. So Justice Samuel Alito announced the judgment for the divided court, and it was divided. It was like 5-4. Justice Alito, joined by Chief Justice Roberts and Justice Kennedy, concluded that the Fifth Amendment's privilege against self-incrimination does not extend to defendants who simply decide to remain mute during questioning. Did you know that? Did you know that you don't automatically get Fifth Amendment protections if you just decide to shut up? It's not enough just to shut up. Before you shut up, you have to say, I invoke my Fifth Amendment rights, according to the frickin' court. But wait, there's more. Longstanding judicial precedent has held that any witness who desires protection against self-incrimination must explicitly claim that protection. It must be explicit, it must be clear, it must be unambiguous. This requirement ensures that the government is put on notice when a defendant intends to claim this privilege. Did you see that? So this is a commentary on the case. But from the perspective of the Supreme Court, your Fifth Amendment right isn't a right at all. It's a privilege. And you don't have it at all unless you specifically invoke it. Tell me that's not crazy, upside down, convoluted world. And allows the government to either argue that the testimony is not self-incriminating or offer immunity. Oh, who has all the power there? The plurality reiterated two exceptions to this principle. One, that a criminal defendant does not need to take the stand at a trial in order to explicitly claim this privilege. They're calling it a privilege, guys. It's not the Bill of Privileges. It's the Bill of Rights. You don't have the privilege of life, liberty, and the pursuit of happiness. A privilege, it sounds like something that was given to you. If you don't have unalienable privileges. You have unalienable rights, rights that weren't given to you, rights that can't legitimately be taken away from you. But the court wants to talk about this in terms and in the sphere and on the level of privilege. What the frick is up with that? And that's why I call them the black robe tyrants of the Supreme Court. That's why I call the supreme law of the land the Supreme Court, especially after 1803 Marbury versus Madison. When you arbitrarily grant yourself the power of judicial review. In other words, I will be the sole arbiter and interpreter of the Constitution. I'll tell you what it means, and I'll tell you how you got to act. Otherwise, you're going to get slammed by the court system. That's being above the Constitution. It's putting yourself above the Constitution, at least since 1803. Now, does that mean that there aren't some good rulings that come down the pike every once in a while from the Supreme Court? No, because good rulings do come down the pike in the Supreme Court, like the one the Warren versus DC, when they said, no, you got the right to self-protection according to the Second Amendment. But then they slap all these, it's convoluted in itself because they slap all these other restrictions on it. But you got to make sure it's registered, but you got to have a 10 or 45 day waiting period or whatever. That is called infringement. I am simple. Shall not be infringed means shall not be infringed. No infringements, no limitations whatsoever. And it's more than you have the right to keep and bear arms. It's that other people don't have the right to keep you from keeping and bearing arms, if that makes sense. So there's more that can be said on this because there are a couple of court cases like Burgess versus Tompkins, and let's see if I can show you this. Burgess versus Tompkins in 2010, and Miranda versus Arizona from 1966. That's where we get the Miranda rights. But just know that according to the Supreme Court, you do not have a Fifth Amendment right unless you specifically, clearly, unambiguously invoke that right. In other words, I invoke my right to remain silent under the Fifth Amendment. Unless you spell it out for them, you articulate it to the cop, then anything that you say can and will be used against you in the kangaroo court of law. I've got the link for this in the description, and people are like, man, that's so expensive. If you genuinely can't afford it, everything will be supplied to you for free. If you can't afford it, then pay it forward for those who can't. It's as simple as that. But knowledge is power. Schoolhouse Rock was right. Knowledge is power. And if you remain in ignorance, if you don't stand on morality and virtue, which the cops are absolutely not doing, then you will sink under your own weight without the aid of foreign invaders. And I am telling you, we have domestic and foreign invaders, but we're more at risk from the domestic LEO, law enforcement organization terror cell, than we are from any Al-Qaeda individual who wants to strap a you-know-what to their chest and walk into an airport.